I'm here on behalf of PS Jerome Ochieng, PS for ICT and Innovation at the Ministry of ICT. My organization, we are policy advisors to the government through the Ministry of ICT. So we draft the first drafts of policy and legislation for the ministry. I'm a telecom engineer, so I should not be here. But because as an advisor, you are sent where the PS doesn't want to go, and you comply. So the topic is that I was told to talk about is the importance of a strong data protection framework in Kenya. And let me start by just illustrate what happened to me today when I came in. At the reception, I was given a form where I put my name, ID, email address, telephone number. I think the only thing they didn't ask me for was my date of birth. If you don't have to be very clever to correlate all that information to find out about my bank and my financial status, isn't it? Question is, did they really need all that information to let me come and make a presentation to you? I'm not picking on Kenya School of Monetary Studies. This happens in every building, including some of your organizations. When we come to pick our reports, because in government, when you apply for a job, there's chapter 6 of the Constitution. You're supposed to get a credit reference report. Again, in the spirit of protecting the guilty, I'll not name the name, but when I went to pick my report, I was asked for so much information that I don't think was necessary for me to pick the report. In any case, I'd already given the information when I was applying for it. Okay, just to conclude on my introductory remarks, I was even asked today for the serial number of my laptop. It's the first time I've been asked this, second time since 1998. 1998, I was asked for my laptop serial number when I was going to work in Ethiopia, in Addis Ababa. I've since gone back to Addis Ababa, they've never asked me for it. The only other organization that have asked me for this, and I'm not hiding this, is the Communication Authority, which is an organization under ministry, and today here. So I don't know whether we're making progress or not. Look, I was trying to tell them, geofence your laptops and devices so that when they leave the gate, an alarm can go off and you can wipe them clean. Why? I didn't even know where the serial number was. So asking for information. So you see, from a personal perspective, that's why we need a strong data protection regime in Kenya. So with that introduction, I'd like to proceed. This is the outline of my presentation. I'll attempt to look at the existing framework and try and relate that to the work that you do, credit information sharing. And then the main thrust of my presentation is actually the framework that we are developing on privacy and protection of personal information in Kenya. Of course, this is not driven by the GDPR, but GDPR is affecting a lot how information is shared and how we transact business. So this was actually driven by the need to implement Article 31 of the Constitution of Kenya. Article 31 talks about privacy, and it gives provisions on how your private information, you have the right to your privacy, and that includes personal information, your home property, and possessions. Similarly, Article 35, on the other hand, says that every public and private, Kenyans have a right, every citizen has a right to access information held by the state or another person required for the protection of any right of fundamental freedom. So those two articles look contradictory, but Article 35 actually is implemented through the Access to Information Act, number 31 of 2016. But in that act, there are 9 exemptions. So you can have access to information held by public institutions or private institutions, but there are 9 exemptions. And among those exemptions is privacy and personal information, security, commercial information, and others. So if you look at that article, you see the exemptions that are there. So When we looked at the credit information sharing environment ecosystem, we are seeing that you're subjected to very many requirements and regulated by various agencies, be it in banking, microfinance, telecoms, retail, hire purchase, you name it. In the Kenya Information and Communication Act, for example, the operators which are licensed by the Communication Authority of Kenya, the regulator, are required to keep the information, subscriber information private. They are supposed to keep it. But for Kenyans, sometimes we do get these numbers with the known names attached to it, despite the fact that we have a law which clearly says that any SIM card must be registered. They tell you, please send me 10,000 shillings on this number. The other number that you know is not your hacking. And, you get this. I think there's no one who is immune. So you wonder what happens. So on the right there, we are attempting to list what we see are the different regulatory authorities that do regulate data. I want to pick on one. It's called the Ombudsman, the Commission on Administrative Justice. They are the regulators for the access to information. But if you look at that law, they have got some very specific provisions there that look at protection of personal information. So, this is just, I think, an elaboration of my previous slide. So I would like to go to the actual reason why I'm here and just share with you what we are looking at. In the interest of full disclosure, I'm actually a member of the task force that is developing this framework. Again, the PS was supposed to be there, but as I said, where he doesn't want to go, he normally sends me. I don't know how many of you want my job. It's not, okay. So on 11th of May, the Cabinet Secretary, the Minister, set up a task force, and I was appointed as a member of that task force. And we developed a bill and a policy. We are a Commonwealth country, so we normally have a policy, then the policy informs the bill, and then the bill goes to Cabinet, then from Cabinet it goes to the National Assembly or to Parliament, it's debated, and it comes out as a law, and when it comes out, it's no resemblance to what was initially submitted, but the principles remain. So the bill is available on that link for public comments. I'll talk a little bit more about that. You notice that this was done on about 2 weeks before the GDPR kicked in, the General Data Protection Regulations of the EU. So the idea was to try and also comply with Article 31, as I said, but also see that if we try and align ourselves to the EU, because we do a lot of business with the European Union. Some key terms that we propose to use in the bill that you'll not find in the statutes that I mentioned earlier that are currently regulating the sector. Data subjects. I think if you look at the Insurance Act or the Banking Act, I think the data, I don't know if those terms are data subjects, controllers, personal data, sensitive personal data, consent. There's no data commission. We are proposing to have a specific regulatory body based on best practice to regulate the issue of privacy and personal information. So this is just something to show why we think that we may need to update, and we hope that from the comments we'll get from you and the public, we can be able to amend or update some of the statutes that do govern the sector. It's so small I cannot even read it myself. I have to put on my glasses. We came out with some policy principles that informed principles that we have in the bill, and these are, for example, accuracy, data minimization, collecting data only for the purposes for which is needed, which is what I talked about when I was introducing my discussion. Then out of those policy principles, we develop some legal principles which are contained in the Act, so that, for example, data is processed in accordance of the right of privacy of the data subject. If you just pick any, you only release data to a third party with the consent of the data subject. This is what we are saying. So that if somebody comes and, you know that for Kenyans, when you go into a building, even to pay a bill, they take your ID, they write your name, telephone number, everything in a book, a big black book. What happens to that data? So we are saying, okay, they can have the book, but if they are going to give it to another person, they must get your consent, especially if for specific individuals. So we have all these principles that inform what we put in the legislation. And then the application applies to all processing of personal data in terms of collecting, recording, organizing, everything. And then data controllers and processors who are either in Kenya or outside, or use equipment that is resident in Kenya or outside, it applies to those. It applies to the data processor controllers, whether they are in Kenya or not in Kenya. And then the data subjects have got several rights that we've proposed. For example, correction of false or misleading data. Today, I don't know what mechanism is there. If I want to, for example, if I went to one of the bureaus that holds my information and I ask them if I can correct my information, I don't think they are obliged to let me do that. Deletion of false or misleading data, for example, and for example, putting in place adequate security safeguards for any information that is archived. And of course, there's the issue of transborder data flow, so that if you have to send data outside the jurisdiction of Kenya, then you must be subjected to a very specific provision. Then we are proposing that we form a new office called the Data Protection Commissioner. That one is a standard term, so we didn't invent it in Kenya, so we just borrowed the name from other jurisdictions. So they're supposed to have a list, maintain a register of all data controllers, and receive and investigate any complaints. Basically, they are the regulator for privacy and protection of personal information. Then we've given some obligations to the data processors and controllers. So they have to apply, so they must be registered by the regulator, data commissioner. So they have to collect and process data according to the law, which we are proposing. And they ensure that they get consent from you as a data subject for you before you take they take information from you. I'm almost done with the presentation so that we can have a more interactive session. So there's a fines. There's two types of offenses. There's specific penalty for disclosure of personal information, 5 million. I don't know whether that is enough or is too much, or a term not exceeding 5 years or both. And then generally, if one breaches the provisions of the Act, generally, again, the fines are the same. And include prohibition, may include prohibition of doing, if the contravention continues. So, in conclusion, there are two email addresses we've provided that you can send your feedback. So the two documents, the policy and the bill, are on the Ministry of Information website, ict.go.ke, as I indicated earlier. And you have until the 12th of September. This is a public participation process, so it's not limited only to Kenyans giving their comments. You can, if you are not a Kenyan, still give comments, send them those two email, either of those two email addresses or both of them, so that we can try and enrich this document. And because I forgot to carry my business cards, and anyway, since I've already given out my personal information, there you are. You can take that and get in touch with me. But at least you don't have my ID number. Thank you very much.
It's time to hear from the ladies. And I'm going to start with the shoes assistant Nancy, Karen from Six, manager for digital financial services. Just to give a few
data subject, how it writes over the data that it provides, and how it's collected, how it's shared, and how it's processed. What I realized from even your example about having to give the data, I also had to give out my data when registering my laptop. And I don't know what they're going to do with that data. A lot of the Kenyans, and specifically Africans just across the market, people don't know what data is being collected and how this data is going to be used. So I think even as we discuss data management and we talk about the data framework that is going to be implemented, we need to think about how we are going to give information to this data subject so that they know that my data is being collected in this way, there's a likelihood it will be used in this way, and this is the match control that I have about it. So that is not only coming from the stakeholder perspective, but it's also coming from the user. In the recent past, we've seen customers at agent outlets going out, giving out the information, giving out their PIN numbers, giving out their cards as they access credit. As we speak about lending to the bottom of the pyramid, how are we going to address these issues? What opportunity has the agent seen in collecting data that is able to give loans through the Shylock system to these people, and he knows that they are not going to default? Because they don't default. He knows everything about these people. He knows who the spouse is, he knows where he works, he knows on which day he's paid. How are we as stakeholders using this information that the agents are so easily collecting and keeping it safe for them while also using it to further our business?
A round of applause, please, for those opening remarks. Shani, who's General Counsel at TransU.
Thank you. Good morning. So my speaking point today is a little bit more around creating some context around how we in South Africa have dealt with this legislation. So our equivalent of this legislation is called PAPIA. It came into effect some time ago. The Act is not fully operational yet. But I thought that I would give you some context today around how we're thinking about this, how we're integrating it into our businesses, and how we're looking around consumer education and some of the themes that are coming through the implementation process. So in terms of our legislation, the pieces are in effect already are the pieces that allow for the creation of the regulator and the drafting of the regulations. The actual legislation is not in play yet. That said, we're getting quite a bit of pressure from customers, especially customers that have presence in the GDPR regions, to start looking at implementing some of those terms and conditions into our contractual agreements. It brings some form of dilemma in terms of how we deal with it, because our regulations are not fully defined yet. We, for instance, have no clarity around how consent would have to be gathered. So it does make it difficult for us to start agreeing to some of those principles practically, because it might change once the regulations come fully into effect. What we've also done is, because we're African-based but impacted, rightly as you say, by the GDPR, we've taken a view to say that we're not going to implement only PAPIA legislation. We're going to implement best practice data privacy principles. So in line with our estimation, there's around 80% overlap between our legislation and GDPR. And we will cater for the additional 20% to make sure that we are as compliant as possible. And based on a recent Deloitte report that was issued as well, one of the recommendations that came out of that as well was a recommendation to businesses to say, well, try and go the most compliant route. As a registered credit bureau in South Africa operating under the National Credit Act, we already have quite a robust culture around data privacy, information security, and safeguarding the individual's personal information. And to the point that you earlier made around collecting your report, one of the reasons why we are very strict in terms of verifying that you are who you say you are is because of identity theft. So identity theft is very prevalent in the South African market, and we find, especially if you work through a contact center environment, that you have to be very sure that the person that you're engaging with on the other end is actually the consumer. And given the diverse socio-economic diversity of our country, this does pose some challenges because some of our consumers are less sophisticated, and it is sometimes through language barriers or levels of education a little bit more difficult for them to actually engage in that conversation to pull that report. And it's one of the things as an industry that we're working quite hard towards to sort of consumer education and making these reports more freely available. Someone mentioned yesterday In Kenya, in terms of legislation, each consumer is allowed one free credit report per annum. We've got the same regulation locally, but what we're trying to move towards is what we call a freemium offer, where we actually make this available at no cost to the consumer, because we feel that once you have that information, you're actually empowered to make corrections to your data, to own your data. And I think a lot of consumers still think that that data doesn't belong to them, it belongs to the bank or to the credit bureau. But actually the message that we're trying to drive is to say that that is your data. So that's just a little bit of context. I think I loved Ray's presentation yesterday, and at an ideological level, that makes me very, very excited. I think practically for where we are, we have a few challenges that we need to overcome. And certainly as a business in South Africa, we are making the transition from not being just purely a credit bureau business, which we were traditionally seen as, but as an information and risk services business. And we've approached a far more what we call consumer-centric or consumer-first approach. Now with that consumer-first approach comes all kinds of other dilemmas. So we spoke greatly yesterday around how easily consumers are prepared to offer their information in exchange for services, in exchange for data, in exchange for all kinds of products and things. And you have to balance this whole concept of privacy against value, and this whole new movement towards instant gratification. You know, as businesses, we continuously talk about frictionless engagement, about a consumer wanting to start balancing that against what is allowed under our credit legislation. But the biggest challenge in this process is consumer education. And I think you've got two extremes. The one is the overly educated consumer that's going to come knocking on your door wanting you to remove all kinds of information off the bureau, which is potentially information that shouldn't be removed off the bureau, which by law a data provider is obliged to submit to the bureau. But then you're also going to have your completely uneducated consumer who doesn't have access to channels where they're informed around how they're sharing that information. And I think there's a great opportunity for us to work with our regulators around that. Someone made the point yesterday also around you having to ensure that your regulation is applicable to your region. And I think that brings a certain dilemma into play for us. So although we've tried to model the GDPR legislation across the African region, we're modeling GDPR legislation, I think we also have a responsibility as corporate citizens in terms of our own economic setup to have those conversations with our regulators, to talk about how we can inform the regulations so that it is practical, so that it does work for the region. You know, we're moving into a space where, for instance, data is hosted in the cloud all the time. And in certain jurisdictions, you still find that there's very conservative notions around how data should be ring-fenced. And it brings quite an interesting dynamic into play around how you enable sort of futuristic thinking and forward-looking business practices while maintaining those strict data privacy principles. I also think it's a journey. You know, if we just look at our credit legislation, we have been at it for more than 10 years. We're still making amendments to our credit legislation today, and I think it's going to be the same with privacy legislation. I think you have to start off in a place, and you're going to have to keep engaging with your regulators and with your industry stakeholders around how this evolves to a point where it actually works for all the parties in the ecosystem. And then maybe just one last point. I see Michael sitting forward on his seat. It's just around the role of bureaus as enablers. You know, being from a bureau, I haven't worked in the bureau space all my life. I've worked in the financial services space. I've worked in practice, and I've got, I think, quite a balanced view around industry. But from a bureau perspective, we're really positioned very well in the center of the ecosystem to enable this process. We've got very robust processes in place around data protection and privacy. We've got the advantage that we connect the consumer to the customer and that we sit in the middle of that ecosystem. And we've got the link to the regulators and the stakeholders. And I think there's a great opportunity for us to collaborate as industry around this and to work around how we actually achieve the best outcome for all parties in this process. So my view is always that I try and be a glass half full person, not a glass half empty person. We've, every time legislation's come into place, we said, oh, this is terrible, it's going to stop our business, we're going to have to relook everything. And every single time we've actually survived the process and we've created a better, more robust economy. I mean, at the end of, so if you look at just as an example our credit legislation and you look at the economic pressures that the world has been under, to some great extent when the credit legislation came to play, business was quite weary of it. They were nervous that it was going to change their business models, make it much more expensive for them to do business. But at the end of the day, it's actually been our saving grace in terms of how we've preserved our economy to some extent with regards to affordability. And I think the same is going to be applicable for privacy. So as a parting word, maybe just collaborate, because it's the only way we're going to get the best possible outcome for everyone in the ecosystem.
Thank you very much. And the floor is officially open for any additional questions that you might have. If I spot you, I'll come. We'll hand you a microphone. But off the back of what Janine has just shared with regard to consumer education, and in the case of Kenya, who takes responsibility for consumer education? Either one of you.
I would say the regulator, the proposed data protection commission, has to carry out consumer education. I think that's a very, very important aspect. Because I think the data controllers already handling data, so there are some insight into what needs to be done, but the consumer probably needs to be told and needs to be comfortable what is being done. So the primary responsibility is the proposed regulator.
And no part to play by the rest of the industry.
Of course, I said the primary role.
Okay,
But then, of course, the regulator is responsible for the whole industry. So the data controllers then, as part of the regulator may require that the data controllers do carry out specific consumer education with the specific consumers that they're dealing with.
Is there a minimum requirement so far of the regulator as far as what kind of education needs to be out there for the consumer?
The draft is out there.
Yes.
So what we're asking, we should interrogate what is provided for there. And then actually, typically, they are going to the regulations which now go into more details on what needs to be done. Yeah, but that comes after the law has been enacted.
Could we know who else is on the task force that you're on?
You're asking me to release people's personal information. Public forum. We have representatives of the Office of the Attorney General, who is the legal advisor to the government of Kenya. We've got the Kenya Law Reform Commission, who are mandated by the Constitution to develop laws in Kenya. So they coordinate the development. So they are actually the drafters. Because Ministry of ICT as a sector that has a lot of data being collected. If you look at for example, the mobile industry, we have the Communication Authority of Kenya, who are actually chairing the task force. We have the Commission on Administrative Justice, the Ombudsman, CAJ, represented because of their currently the regulator for access to information. We have Article 19 to represent civil society in the drafting, just the drafting. Then we have an online policy discussion group called Kikale in Kenya, ICT Policy Network. So we have a representative there, but he also is a professor at one of the universities. So he's representing academia as well as the policy advocacy groups. That's what I can remember for now. But we try to have a cross-cutting presentation. But basically, ours will just develop the drafts first. Yes. And then now we're doing this open consultation, and we go through a process of collecting information.
All right. Thank you. I can see your raised hand is up. Do you have a microphone? Go ahead.
Hi, good morning. Thank you all for a fascinating discussion. I have a question specific, two questions specific related to the draft bill. The first is the regulations that will be issued. Are those going to be primarily issued by the sector regulators for different segments of the economy? And then also, how will we handle, if we think of financial services, we have certain sectors, lending being one of them, where you have a mix of regulated and unregulated lenders. So a sector regulator could issue rules based on the authority the law would enact, but it wouldn't cover all those providing that type of service and capturing that type of information. So is there a thought on how we address this significant problem of gaps in regulatory coverage we have in financial services vis-a-vis data protection? Thank you.
You need to protect me. Yeah, that's a joke. Yes, the regulations are not the issue, but the regulations are going to be about data controllers and data processors. So even if you're not a regulated sector, but you're a data controller, a data processor, then how you handle that information is important. So my inkling is that it's not about whether a regulated or unregulated sector, but the fact is that you're collecting personal information and you have to be very clear how you handle that information. In the event that there is a cross-jurisdictional, there's responsibilities that are crossing the more than one regulator. We have a way already. There's precedent set in Kenya where you have two regulators, the telecom regulator and the financial services regulator, actually working together to develop the mobile money ecosystem in Kenya. So I think at the time where maybe there's a constitutional responsibility, I think that should be. And again, as we are doing now with the policy and the bill, the regulations will be published, they go through a public stakeholder consultation. Maybe not everything will be agreed, but at least it goes through that process. So at the time of the regulations, kindly, if it's a matter that you're interested in, just participate and let your voice be heard, and usually we try to take on board and find a solution that leaves everybody equally unhappy.
Nancy, are there any solutions as well that you've come up with in protecting data that could be taken up in the broader regulatory framework?
Okay, so a lot of what we've done has included reviewing of business processes because we have a lot of loopholes. Sometimes we'll have our own internal risk units and data units within the company, but there are small things here and there that they will not be able to see. Having worked with the consumer on the ground, then when we have their information or we understand how the consumers think, when we go into the institution and we are looking at reviewing the business processes, then it becomes very easy to make sure that we get a balance between what the institution gets as data and how they're able to protect the data that we collect from the consumer while at the same time protecting the consumer interests.
If I hear you right, review of business processes, yes. Frequency shows something that is embedded into I see you nodding. Is that the case?
So one of the things that we're reporting is almost instilling this culture of data privacy within our teams on the ground. Because it is really something that's becoming part of the DNA of the organization. And we're a compliance-driven business by the nature of what we do. And so our thinking that's how we'll instill it is to sort of reinforce that culture and thinking continuously.
Finally, what informs 5 million shillings?
This, I think, was introduced by the two bodies that drafted for us the bill. I'm not able to answer specifically, but I would say that they must have looked at the damage that you do if you release my information, for example. What does that mean as a person? And probably you deserve that 5 million and those things. But they must have it was informed by something. But again, it's a proposal. And it's maybe compared with other jurisdictions. But I don't know what informed it, but I can imagine tomorrow I find the form I feel here published in the newspapers with all the things about it. I think the person maybe that deserves to be jailed for life. I think so. I would say 5 million would be reasonable, if not lenient, for somebody for breach over disclosing personal information. But maybe you can have the experience from South Africa. I don't know what it is from other jurisdictions.
Very quickly, Jenny, what's the fine?
So we typically find that our fines are also quite hefty. And in terms of our buying legislation, we do actually also have the ability for your CEO to go to prison. So one of the things when I introduce myself to people, they say what I do, I always say I keep our CEO out of jail. So I think the point is that it needs to be big enough that it's a good deterrent for people not to transgress. And what the actual amount is does become a subjective thing, but I think it's that principle of deterrence.
Great. We have the final remarks, starting with Nancy, just the closing remark, and then we can wind up the session if there are no other questions.
Okay, as stakeholders, I'd really want to urge us to think about how we can how we can empower our customers, how we can give them information in terms of how do they share their data, what we are going to be using their data for, how we process it, what rights that they have. And as we collect the data, let's see how we can continue to use this to improve our business processes while at the same time making sure that our consumer is protected.
Thank you, Nancy. Nancy Carrier, Microsoft, please, a round of applause.
From our perspective, it's all about the consumer. When you think about a product, a service, even if your mindset is a capitalist mindset with the aim of making profit, at the end of the day, all of that hinges around the consumer and whether the consumer will want to consume your service. And I think if you think about data privacy in the same way, and you put the consumer first, it becomes a much easier process for you and your business.
Thank you very much. Janine Nordlund-Horn. Is that right? No?
No dear. No dear. No dear. That's it.
Janine Nodia.
That's it.
That's it. What happened to the V and the I? Thank you, Janine. A round of applause, please.
Yes. The ICT sector, we are seeing these new technologies that are coming in, big data analytics, artificial intelligence, 5G. Last week we saw Australia banning some two companies from the country because they don't think that they'll be able to keep Australia data secure, so they're being banned from rolling out their 5G network. Our sector, which supports your sector, is developing this new technology, and we believe that security of personal information and privacy is so important. Otherwise, people will not feel confident if they know that their data is not secure to transact using these new technologies. So it's important that actually this matter of privacy and protection of personal information is ingrained in our processes. As Janine said, we have to really involve our business processes so that the default is protection of personal data. Secondly, again, an appeal, please go to the ministry website, look at the policy, look at the bill, and let's not have it after we've enacted, and then we have to say, no, this was the worst, this is the worst law that's ever been made. Let's try and engage between now and the time of the enacted so that we have something that can work for both of us as government and also for you as an industry. Thank you very much.
Thank you very much. I got the tweet. Thank you. A round of applause for Robert, please.